Good afternoon, everyone, and welcome to the Board of Pharmacy's webinar today. I'm Tom Glinsky, Chief Inspector with the board, and today I have Kim Grinston, our Executive Director, who's going to give us a legislative update for this year. Before I turn it over to Kim, I'm going to go through some just some general information about our webinar. All participants are in listen-only mode. If you have any trouble with audio today through your computer, you do have an option to dial in using the information on your GoToWebinar toolbar. If you do have to dial in, do not disconnect, do not close your browser. You want to stay online throughout the webinar through the computer, through their program. This has been approved for an hour of pharmacy continuing education. You must be logged in individually to the webinar. If there's more than one in the room listening, only the one who's logged in will get credit. I will go over the CE instructions at the end of the webinar. Just a reminder, CE is not submitted to the CPE monitor, so save your certificates. Handouts are posted in two spots on the board's website under the upcoming events page. We have a link to them. And then on your GoToWebinar toolbar, you'll see here the example is you can click on the handouts and download them yourself directly from the webinar. We do make a recording of today's webinar and we post them with all our previous webinars on our webpage. We plan to have a little bit of time for questions and answers at the end of the program. If you'd like to submit us a question during the program, just type it in on your toolbar and hit send, and we will try to get to those at the end. So now I'm going to turn it over to Kim.
Thanks, Tom, and good afternoon, everyone. It's always a pleasure for us to do these webinars as a means of communication with all of you, our licensees and the compliance officers that are on the webinar, but also to share information and updates from the board. We have a lot of information to go through. The webinar is entitled the 2020 Legislative Update, but we'll also be looking at rule updates. We have several things that are changing in Missouri that are very important. We will try to leave some time for questions at the end. I'd like to stress, if you have a question, please use the toolbar and leave your question there. We'll try to get to them and we'll be reading them as they come in. Let's get started. We're going to cover a couple of things today. Again, 2020 statutory changes, regulation updates, and then do just some brief licensing reminders and then answer questions that you may have. Let's start with the 2020 statutory changes. So we had two major bills that passed this session. Now, I want to give the disclaimer, this is not a full review of all legislative and rule language. We encourage licensees to go to the board's website and look at the actual bills, new statutes, and new rules to make sure you are fully compliant. Our goal here today is just to give you a bird's eye view. We'll get a little more in depth on the rules, on some of the things that have passed and or may be changing in Missouri, walk you through those, and then answer questions. So we had two major pieces of legislation in 2020. When I say we, they were not sponsored by the Board of Pharmacy, but they will impact pharmacy. And they are House Bill 2046 and House Bill 1682. We'll start with House Bill 2046. It included two main provisions, a new provision related to reciprocity and also the Fresh Start Act. I would note that these changes are to Chapter 324 of the revised statutes of Missouri, which govern the Division of Professional Registration. So many of the changes relate to all of the licensing boards at the division, while some may be pharmacy specific. Looking at House Bill 2046, first it included a reciprocity provision, which essentially added an expedited reciprocity application process for military spouses and licensees registrants coming in from other states. The new language would require that applicants coming in by reciprocity and seeking to take advantage of the expedited process must be licensed in the other state for a year and not have any relevant disciplinary action. The new language provides or mandates a 6-month application approval time. So the thought was to speed up reciprocity applications and the time it takes to get those approved. That 6-month time is quite above the board's average right now. Our average application processing time is from 7 to 28 days, depending on the type of license. Of course, if you're a graduating pharmacist and you need to study and schedule the MPJE, those applications take a little bit longer, while our technician and intern applications may be issued in a few days and maybe under a week. Pharmacist applicants would still be required to take the MPJE at the designation of the board under 2046. 2046 also included what's called the Fresh Start Act. The Fresh Start Act was focused on allowing applicants who have criminal history to ease into licensure by removing and or designating certain criminal history offenses that could be reviewed by the licensing boards. This new language is still under legal review, but it will change the process for some of our application lines in regards to looking at and reviewing criminal history. One of the major changes is that the bill would allow applicants to petition the board to review their criminal history prior to submitting an application. Once the board makes a decision on their criminal history, that decision is binding. That's a quote from the statute. And it basically gives licensees a way to find out if they are eligible for licensure with the state of Missouri. Please monitor the board's website for additional communication on this. Our board attorneys met actually this morning to discuss the impact of the Fresh Start Act on the Board of Pharmacy. We'll have more information on that as we work through those provisions. All of the new legislation, I must say, becomes effective August 28th. So this is not effective now. However, if you go to the board's website or to the state of Missouri's website and look at the current statutory sites, you will see the current statutory language in the official code for the state of Missouri, highlighted in red, noting that it has an August 28th effective date. The other major piece of legislation was House Bill 1682, and it included 2 new changes. One of them was enacting a Class Q charitable pharmacy. So it's a new permit classification for charitable pharmacies. The board will have to define what a charitable pharmacy is by rule and has begun working preliminarily on standards for a charitable pharmacy. Your Class Q pharmacy permit class will not be available until the rule is promulgated. How Class Q will integrate with our other licensed pharmacy classes right now, we really don't know. Again, this is still under review by the board. Anyone who's interested should take a look and monitor the board's website. Class R, remote dispensing site pharmacies, and we'll provide some information on that in just a little bit. That was a new classification that was added in 1682. And then there were some changes to over-the-counter pseudoephedrine related products that Tom's going to walk through in just a minute. Before we get to PSC products, let's talk about Class R remote dispensing site pharmacies. Unfortunately, we don't have a lot of information on this other than the statutory language. The board is currently working on a rule. We've looked at 2 drafts. The board will be meeting again on August 26th. I would note they just met a week ago to look at this rule, and they will be looking at hopefully a final version of the rule on the August conference call. The board is asked to potentially file a rule in September. We may try to do that as an emergency rule that would allow the rule to become effective in the month of September. But again, please monitor the board's website. Again, can't give a lot of specific information about Class R right now because there are a lot of things that would still need to be developed in statute. But what you see right now is the definition of a Class R remote dispensing site pharmacy. Essentially, a remote dispensing site pharmacy is a pharmacy that is located at a designated location that is staffed by 1 or more qualified pharmacy technicians. That term is undefined, or an intern pharmacist. Essentially, a qualified pharmacy technician or an intern pharmacist would be allowed to prepare, dispense medication under electronic supervision by someone who's located at a supervising pharmacy. So all Class R remote sites would have to be supervised by another Missouri licensed pharmacy. That will likely be a Class A, a Class B, or a Class C pharmacy, but they would need to be under supervision. Class R remote sites are not authorized to operate on their own. They are a subset and actually monitored by the supervising pharmacy. The thought was to make, we understand, was to make pharmacy services more available in areas where you may not have a pharmacy and to allow technicians to be used in that space. A couple of restrictions in the rule. So a Class R pharmacy would need to be 10 miles away from a retail pharmacy. That is in quotes because the statute does not define retail, and the board will be trying to define that by rule. The supervising pharmacy must be in the state of Missouri and within 50 miles of the remote dispensing site. So generally, you couldn't have a supervising pharmacy in Kansas City and then a remote site in St. Louis. There is a mileage restriction there, unless the board approves otherwise. And the board is working on standards for approving an exemption to the 10-mile or the 50-mile or the located in Missouri portion for supervising pharmacies. The statute provides, and again, this is by statute, I want to note, this language was not sponsored by the Board of Pharmacy. We were allowed a chance to give input on the language, but this language was not developed by the board. But the statute says that if the average number of prescriptions at a Class R pharmacy exceeds 150 prescriptions per day, that pharmacy must then convert to a full Class A, Class B, or Class C pharmacy. So essentially, Class R sites should be under 150 prescriptions. If they go beyond that, the legislature has determined that it must now operate as a full pharmacy, which means that a pharmacist must be present, as would be required for any other pharmacy. We'll walk through that in a minute. This is still under legal review. How do you monitor that? And how do you calculate that 150-day requirement? We are fleshing through some of those items in rule right now. For those who are interested, please continue to monitor the board's website. We'll talk a little bit about Class R in just a moment when we talk about some of the rule changes, but now I'd like to, Tom's going to walk through some of the changes to BNDD statutes.
Thanks, Kim. So we had a couple revisions affecting BNDD statutes. The first one is affecting the sale of over-the-counter pseudoephedrine. This, as Kim said, this becomes effective August 28th. It prohibits the requirement for a prescription for pseudoephedrine products, and it specifically voids any local ordinance or regulations that require a prescription. So if you're in a county or a city or a jurisdiction that impose their own ordinance saying it can only be sold on a prescription, that will become void on the 28th. In order for you to sell pseudoephedrine over the counter, the pharmacy will have to be signed up with NPLEX, that's the National Precursor Log Exchange. And must be registered with them and submit the sales to them, and then that comes back and gives you whether it can be sold or not to that customer. So if you're at a pharmacy that is not signed up for them and you're going to need to, the link, Appriss Health is the company that runs the NPLEX database. Here's a link to that website if you need to find out how to get registered with them. Prescriptions are still allowed. It doesn't just ban prescriptions. So if a patient needs one for insurance purposes or to get the drug covered on Medicaid, a prescription is still allowed. It's just that it cannot be mandated that you have to have a prescription in order to obtain pseudoephedrine. We have been asked about what about if a pharmacy just has their own standalone requirement that they only sell it on prescription. Our first read of the statute would prohibit that. However, since this is a BNDD statute, we would advise you to contact them for guidance and also seek legal advice from your attorney if necessary. Pseudoephedrine sales limits also were revised in this bill. So below here in red are the changes that were made. There was no change made to the 24-hour limit, but there was a decrease in the 30-day limit. It was reduced from 9 grams to 7.2 grams in a 30-day period. And then it created a new limit, which is a 12-month limit that no patient can receive more than 43.2 grams over a 12-month period. So again, these sales limits become effective on August 28th. I have been informed that NPLEX was made aware of these, so you may be seeing some new rejections come back on patients who exceed these limits, especially the new 12-month limit. Any questions related to the pseudoephedrine stuff I'm talking about here, you can direct those to BNDD, since this is their statutes and they're the ones that enforce the pseudoephedrine requirements. It's best to contact them through their email, which I listed here. Another change in BNDD statutes had to do with where a filled controlled substance prescription can be delivered. In the past, BNDD statute prohibited a pharmacy from delivering it to a practitioner. That has been revised now to allow it, and the actual language that was added is here in red. So if it's being delivered to a practitioner so they can administer it to the patient, that is now allowed. An example of this is the Spravato, where it needs to be delivered to the practitioner. That will now be allowed for a pharmacy to do that and comply with the statute now. It does have some, it's a line in there about what a practitioner has to do. Again, that's on the practitioner, not on the pharmacy, about how the practitioner keeps their records. So that summarizes the BNDD statute changes. And again, any questions about those can be directed to BNDD.
Thanks, Tom. So I see that we have questions coming in about different things. We'll be going through those at the end of the webinar. And again, if you have a question, please enter it in the chat box, and we're going to try to leave as much time for questions as we can. So we talked about legislative updates. Now let's talk about rule updates that have been made by the Board of Pharmacy. And we're going to look at several rules, and many of these will be familiar from some of the COVID-19 waivers for most of you, but for some of you, there may be some differences and/or this concept might be new. So 3 new rules that are going into effect or in effect, and they are 20 CSR 2.710 on pharmacy technician and intern pharmacist supervision, 2.725 on remote data entry, and 6.055 on non-dispensing activities. And it may help if I give just a little bit of background on what the board has been working on with these rules. Many of you may remember we talked about this last year, that the board has begun initiating a standard-based regulatory approach where we move away from a very prescriptive type of regulatory approach, and we instead allow and expand pharmacy practice to accommodate a pharmacist's discretion. One key element of that is the role of technicians and intern pharmacists, how they're supervised, how they're able to assist, and what they are allowed to do. So the board is considering several concepts. We are looking at changes to 2.010, which is the main pharmacy compliance rule, also to the technician rule itself. But the board started and made the decision to begin its review looking at what technicians or how, technicians are supervised, and then where they're able to practice. So those are the changes that you're going to see over the next several rules. 2.710, so section 338.010, which is statute, says that text intern pharmacists can assist the pharmacist under the direct supervision of a pharmacist. We've gotten several calls about what does direct supervision mean, and it was undefined in statute or rule. Under Missouri law, the board can't impose a definition that is not in statute or rule, so we were unable to answer those questions in the past. What the board did is the board decided to actually look at that definition of direct supervision and define it. And I want to note that this definition applies to those entities under the board's jurisdiction. I want to stress that. So direct supervision, 2.710 will officially define direct supervision as supervision by a Missouri licensed pharmacist who is, number one, readily and immediately available. At all times delegated tasks are performed, and who provides the personal assistance, direction, and approval to make sure delegated tasks are being performed properly. So I note that this is a 1-2 approach, and we'll see how that plays out in just a little bit. But the pharmacist must be readily and immediately available and also must provide the personal assistance needed to ensure that tasks are being properly performed. Ready, immediately available, what does that mean? 2.710 defines readily and immediately available as either one, a pharmacist who's on the same physical premises as the tech or intern pharmacist. You have a pharmacist who's there at the pharmacy, or technology can be used to supervise the tech or intern's activities. So you can have a pharmacist physically there and present who is able to provide personal direction, or technology can now be used to supervise the tech. There are going to be some very clear caveats in just a moment, so please just hold a pin in that, if you will. If you're using technology, the pharmacist must be able to communicate with and monitor the tech's or intern's activities. One of the things that the board decided not to do, and you'll see this here again, the board decided to choose a standards-based approach. They wanted to empower pharmacists to use their professional judgment and discretion. We don't know everything that a technician may be doing for you, or how your technician is trained, or what technology you may have at your pharmacy. The board, instead of doing a very prescriptive approach that would say you were mandated to use a certain type of technology, left this determination in the hands of pharmacists. So you need to ask yourself the question, when you're using technology, what's adequate to communicate with and monitor the technician's activities? And again, that and is important. You must have more than the ability just to communicate and talk with them. You also have to be able to monitor. Now, what does monitor mean? And we'll talk about that in just a little bit. Does that mean video? Does that mean video on demand? Or if I have an app on my phone and I can see what's happening in the pharmacy if I need to, does that qualify as communicating with and monitoring? That is really in the pharmacist's discretion. Again, under standards-based approach, the board purposefully chose not to be very, very prohibitive here, to allow pharmacists and pharmacy flexibility. You should also be asking your question, what's needed to make sure that the tasks that they're performing are being performed safely and properly. Again, pharmacies, the PICs, the permit holders, you are still responsible for the activities of those you're supervising. So you should be making a determination on, when I look at technology, what is adequate to allow me to communicate with the tech, monitor the tech, and make sure that they're operating safely and properly. You also don't want to forget about security requirements. You are still responsible to maintain adequate security. So that also should be a factor when determining what technology you'd like to have in place. Audio video determination is in the pharmacist's discretion. We're going to see some caveats to that in just a little bit, but generally, the type of audio or if video is necessary is again rested in the hands of pharmacists and the permit holders. This is the exception screen that I want everyone to please focus on. While we have now authorized technology usage or technology-assisted supervision at a pharmacy, technology still cannot be used to supervise the following tasks. And this is under 2.010. This is the pharmacy, I think it's the Pharmacy Standards of Operation rule. That rule has not been amended. But technology cannot be used to supervise a technician who is compounding, preparing medication, dispensing or providing medication to patients, so they can't dispense something out of will call. They can't also pharmacists cannot remotely verify the final product. So while this is a step towards allowing technology usage, it still maintains the requirement that a pharmacist must be physically present. You see that language from 2.010 at the bottom of the screen. If a technician is compounding, preparing medication, dispensing or providing medication to patients, and a pharmacist cannot remotely verify the final product. So you have a technician who's there, and we'll walk through some examples in just a little bit. They can be supervised doing data entry activities and other functions that are not listed here, but if they're compounding, if they're counting and filling, if they're doing any of that, putting it in will call, handing it out to the patient, even if it's been previously verified by a pharmacist. Pharmacists must be physically present and able to render immediate assistance. Now, this standard is under board review. The board will be looking at 2.010. The board decided that they wanted to do that as a step 1, step 2 kind of process. COVID-19 sort of interrupted that review, but the board will be looking at that again under 2.010. That could change in the future, but for right now, this is the standard in Missouri. And I think that this does stress the importance of the expertise and professional judgment of a pharmacist on site. But again, the board will be reviewing that going forward. If you're supervising via technology, a few additional requirements: the technician or intern must complete employer-approved training in the activities performed. Again, this is a standards-based approach. The board is not mandating that anyone be certified or that they complete any specific training. The pharmacist, the PIC, the permit holder, should be talking about what type of training is required. We're allowing you to use your professional judgment here again without being very restrictive. After completing approved training, there must be an initial and annual documented assessment of competency. What that looks like is, once again, in the pharmacist's discretion, the permit holder's discretion, but you must make sure that they are documented to be competent at whatever it is you're delegating. So if it's data entry, however you choose to do that and document that, that has to be done under the new rule. There also has to be an audit trail of data entry and modifications to the patient's record by a tech or intern while they're being supervised via technology. I would note that these training requirements, the documented assessment of competency, only applies if you're supervising through technology. If a pharmacist is going to be on site and you're not supervising via technology, these would not apply to you. Again, pharmacists and permit holders remain responsible. You can't delegate supervision or supervise via technology and not be responsible for what's happening while you're not in the pharmacy, and you must ensure compliance with all applicable state and federal law. That would include also all security requirements. Let's walk through a few examples of allowed activity here. So this comes up often. You have a supervising pharmacist, staff pharmacist for the day is on a lunch break, but they are in the break room and they are available to answer questions from techs or interns and to provide assistance if needed. That is an example of allowed activity. So under 2.710, they are considered reasonably available. You don't necessarily need technology to supervise here because the pharmacist is on site and on the premises and they are available to answer questions. That is something that would be allowed. So we get questions that sometimes about pharmacists who may be nursing or pharmacists who may be outside of the pharmacy just temporarily or on the premises, but just not at the dispensing counter temporarily, but they are available to answer questions. This is now allowed and addressed by 2.710. Another example of something that is allowed by 2.710, you have a pharmacist that's not on site. You've got a pharmacist who's at another Missouri licensed pharmacy, maybe at Pharmacy B, if you will. Note that says Missouri licensed pharmacy. And that pharmacy, Pharmacy B, is supervising the techs using compliant technology. They can communicate with and monitor what the techs are doing. That is allowed. So you can have a Class A, Class B arrangement. I would note that the pharmacist that's supervising doesn't necessarily have to be at a Missouri licensed pharmacy. This is provided just for example purposes, but they could be at any location supervising via technology. So again, pharmacist is not on site. You have a pharmacist who's home who has access to an audio, maybe video system, and they can watch the technicians until the pharmacist is there. That is allowed, except for compounding, dispensing, providing medication, and they cannot remotely verify the final product. Another example of allowed activity happens a lot because we get the phone calls from your techs. Pharmacist is running late, but the pharmacy still needs to open. You have to get the day started. Pharmacist is able to communicate. They may have, again, some kind of technology that allows them to talk with the pharmacy techs if needed and to monitor what techs are doing at the pharmacy or interns. I'm using the term techs, but it would apply to interns as well. Once again, that is allowed if they're using compliant technology. Now let's talk the other side of that. What's not allowed? So, and again, these are examples that have been presented to the board prior to promulgating the rule, and I think the rule will address some of those. So you have a pharmacist who's at lunch. They've been asked not to be interrupted, and they're not available to answer questions. They may be on the premises, but they don't want to be bothered. The door is closed. In that circumstance, the pharmacist is not reasonably available because techs can't answer questions. They are not there to provide immediate assistance. So that means intern activities have to stop until the pharmacist is able to directly supervise again. And also the no pharmacist on duty sign must be posted. Now contrast that with the example that we looked at previously, where you have a pharmacist who is at lunch or on break, but they are open and available for questions. And if you need them, they can always come back into the pharmacy and answer those questions. Those are two different scenarios. What's not allowed is supervision by a pharmacist who is not available and is not taking questions from staff and cannot intervene. Another example, this comes up also surprisingly often. Pharmacist is on break in the pharmacy parking lot. I guess that's the seclusion place, but you have a pharmacist in the parking lot, so they're technically around the pharmacy, but they're not available for questions, but or to assist technicians. Again, they're not reasonably available. They're not there. They can't provide the personal assistance that's required by the rule. It doesn't meet the definition of readily and immediately available. So tech activities have to stop. And again, no pharmacist on duty sign. Another example, you have a pharmacy who's remotely supervising the pharmacy using technology. The pharmacy can talk with the techs, but he can't monitor, or she can't monitor what activities are actually happening there. That is an example of, again, of what's not allowed. The required technology must allow the pharmacist to both communicate with and monitor staff while the pharmacist is supervising. And again, this would apply if you're using technology. If the pharmacist is on site and available, of course, that would be allowed. Staff pharmacist is running late, so techs call the PIC, and the PIC says, and there are patients in line, that they can go ahead and dispense everything in the will call bin that was already checked by a pharmacist. They have technology to communicate with and monitor pharmacy staff that complies with the rule. This is not allowed under the rule. I want to stress this very firmly. Once again, techs, interns cannot compound, prepare, dispense, or provide medication unless there is a pharmacist physically present in the dispensing area. And that's currently the rule under 2.010. Now, there was a COVID-19 waiver that was issued earlier this year that would allow pharmacists to remotely verify a final product if needed to provide emergency relief, and you weren't able to find a pharmacist to do a final verification. That is still in effect. So while I said that the rule doesn't allow you to remotely verify the final product, if you fall under the COVID-19 waiver, then you can still do that until that waiver expires on December 30th of 2020. Again, this is not that remote final product verification waiver allowance is not just for pharmacists who are running late. It's if you need to send the product out to address an emergency and you cannot get a pharmacist there to perform the required verification, that is still in effect until the end of the year. Class R pharmacies that we talked about earlier will change that, and we'll go back and walk through some of that information in just a bit. So that's 2.710. Let's move to a related rule, also dealing with tech and intern activities. What you'll see here is a lot of duplicity. The board tried to be consistent throughout the rules as much as possible to avoid confusion, also to make it easier for licensees and also technicians and interns. But 2.725, again, this is familiar to those who provide or performed remote data entry under the COVID-19 waiver that was approved by the governor. But basically, the rule officially allows techs and interns to perform remote data entry activities offsite, from home, if you will, or from another location. The remote site must be located in Missouri under the rule. Now, this is different from the COVID waiver. The COVID waiver basically said that you just had to be assisting a Missouri licensed pharmacy, and you could actually be a technician in Illinois assisting a pharmacy or doing remote data entry for a pharmacy on the Missouri side, and the waiver allowed you to do that. That waiver is still in effect until December 30th of this year. Beginning December 31st, the remote data entry site must be located in Missouri. Pharmacy, the supervising pharmacy must maintain a list of all remote sites. You have to have a policy and procedure manual. The supervising pharmacy and the technician, they have to share a common database or a prescription record-keeping system that allows real-time online access to the patient profile. This language is similar to Class J requirements, but that you have to have a real-time common database or access to the record-keeping system. Again, techs and interns, they have to be competent in the duties performed. They have to complete an employer-approved training program. They have to have an initial and annual documented competency assessment. And you also have to identify the tech or intern who is remotely entering, validating, or modifying data electronically in the pharmacy's records. So it mirrors 2.710 here quite a bit. Again, standards-based approach, the type of training, type of documentation, that is up to the pharmacy. You can document the tech's initials, their sign-in code, as long as you can identify for the inspector who actually did the modification or entered the data. Pharmacists, again, must provide personal assistance, direction, and approval, same as 2.710. Pharmacists must be available to respond to questions at all times. Now, this is different in 2.725. Along with the next requirement, there must be a real-time communication mechanism that allows the pharmacist to talk with the technician or intern in real time. The site cannot be operated if that communication mechanism is not working. That could be as simple as a phone. It could be two-way video, as long as you can communicate in real time. Standards-based approach, it's in the discretion of the pharmacist and the permit holder. Pharmacists must be readily and immediately available. Well, I'm sorry, I skipped to the next rule, but that still applies to 2.725. Remote data entry, hopefully this will go through seamlessly. Please, if you have any questions, talk with your inspectors, and they will be able to help you. You can also email the board office. 6.055. So we received a request, the board did, maybe about 18 months ago now, asking about technicians assisting pharmacists outside of the licensed premises with non-dispensing activities. Many of you have seen and may be involved in technicians who are operating as community health workers and doing some of those additional activities off-site. Pharmacists have asked, if I go off-site to do a consult or a diabetes clinic, can I bring a technician with me? In the past, we've said no. Unless that site is licensed as a pharmacy, the board has opened that requirement, and technicians can now assist with non-dispensing activities off-site. Assist a pharmacist off-site. And it's the requirements again will mirror 2.710. So a pharmacist must be on the same physical premises where non-dispensing activities are being performed, or you have to use the same compliant technology that we mentioned before. Like the remote data entry rule, pharmacists have to be available for questions, and there must be a real-time communication mechanism that's in the discretion of the pharmacist. Tech intern must be competent. Again, there goes that documented competency assessment. And of course, security and confidentiality must be maintained. Techs and interns cannot, and this is under any of the new rules, actually under any rule of the board, they can't do anything that requires a pharmacist's professional judgment. So while they're performing remote data entry under tech supervision under 710 or assisting off-site, they still cannot do anything that requires a pharmacist's professional judgment, and they can't receive or accept a verbal or written prescription outside of a Missouri licensed pharmacy. Now, this is a statutory requirement. You'll see the statutory site there on your screen, section 338.095. It specifically says that you cannot accept a verbal or written prescription unless you are on the premises of a Missouri licensed pharmacy. So I know this may look a little bit busy, but I thought I'd try to do just a chart to sort of compare what the different rules are and what they say. So the first column relates to those instances where you have a tech on site and the pharmacist is off site or not available. And then the other rules that are going into effect, as well as the new Class R statute. Again, there are a lot of things about Class R that is still need to be determined. You'll see, is technology assisted supervision allowed? Yes, for all categories. A real-time audio communication mechanism that is required for remote data entry, non-dispensing activities in Class R, but it is not necessarily required under 2.710, meaning tech is on at the pharmacy, unless the pharmacist determines that they need a real-time audio communication to properly supervise. Video technology, you'll see that that is not required, but may be appropriate if needed to safely and properly supervise tech activities. However, it is required under the Class R rule. Completion of employer training, you'll see that is required by all rules, still to be determined by Class R. That documented competency assessment, you'll see it's the same there. All rules require it except for a Class R that is still to be determined. Thought I'd also do a comparison for you so that you can see what happens. And this chart, I have to be very clear, only applies when a pharmacist is not on site at the pharmacy and a tech is being supervised through technology, or not on site at the premises or the location where the technician is performing duties. Just to drill this point in again, compounding, pharmacist has to be there unless you're a Class R, rule is pending on that. Counting, filling, preparing meds, again, that's not allowed. Even if you use compliant technology, pharmacists must be there. Dispensing, providing the final product, not allowed except for a Class R. Pharmacist has to be on site. Data entry is allowed under all 4 scenarios with qualifying technology or if the pharmacist is on site. Except written prescriptions, we just talked about this. It can only be done on the premises of a licensed pharmacy. So it would be Class R in any other pharmacy that may have a pharmacist on site at the pharmacy or using supervision technology to supervise the tech. That's the same for written and verbal prescriptions, remote data entry sites, off-site non-dispensing facilities. You cannot accept a written prescription. So let's say you have a technician that's going out to a long-term care facility to collect some patient data, or maybe to an off-site clinic. They're collecting patient data. The prescriber wants to give them, some paper prescriptions to take back to the pharmacy for filling. You cannot do that at a remote data entry site or off-site non-dispensing activities. And in fact, a remote data entry site, you probably wouldn't have that interaction at all. We are releasing an August newsletter that will have all of this information in writing. It's in draft stages now. It should be released hopefully by the end of this week, if not early next week. So if you didn't catch all of this, go back through the slides, but we will have it in the board's newsletter as well. As we get closer to the 1 o'clock hour, I just want to hit just a few licensing reminders very quickly. For all pharmacists, we are in renewals. You have to renew by October 31st. CE has been reduced to 15 hours due to COVID-19. Thank you to everyone who called the board who asked if the board's email was hacked. We were not hacked. CE has actually been reduced to 15 hours. MTS and blood clotting therapy it still applies. You still need to complete that required therapy if you have an MTS certificate, or if you're dispensing or advising on blood clotting therapy products under the rule. However, that CE can be part of your 15 hours. CE must be earned between November 1st of 2018 and October 31st of 2020. Please check some of your national CE sites and providers. Last year, we had a major provider who had the wrong dates for Missouri, and they were clearing Missouri pharmacists as meeting their CE requirement, but the dates were out of our date range. So if you're using CPE Monitor, whatever else you may be, not CPE Monitor, but Pharmacist Letter, if you're using any of those to track dates, just make sure their dates are correct for Missouri. CE has to be complete when you renew. If you have a notification of intent to administer medication by prescription order or immunize by protocol, remember you have to renew that as well. It will not automatically renew with your pharmacist license renewal, even if you do it online. If you submitted a paper renewal, you're going to have to go online and renew your NOI. If you did an online renewal, you should have gotten to the end of the renewal program and the survey, and it would have asked you if you wanted to renew your NOI. If you've forgotten, it's not too late. You can just go back and do it separately between now and the 31st of October. This is just a website shot of the NOI page. For those of you who aren't familiar with it, please do that online. We do not have a paper NOI process. For NOIs, a couple of notes that CPR and current BLS certification has been waived due to COVID-19. If you are unable to complete those, a lot of classes aren't doing that live training component that's required by the rule. You can check a waiver box during your renewal process. We are doing that on the honor system. So if you request a waiver, we will honor it for this period. But if you are able to complete it, you should do so. For NOIs to immunize by protocol, that CE has also been waived. It's a COVID-19 waiver. So if you have not completed your immunization CE for this renewal period, you can again check the box for a waiver. I did want to note, and this information was provided this morning, that the CDC has released a series, though, of CE programs that are ACPE accredited. They are a series of just different things on different areas of vaccines. You'll see that on the screen. And they have some that are planned for the future. All of these are ACPE accredited. They're also free. They don't have a cost. So if you're looking for CE, either to meet your 15 hours of CE for this period, or you need to do your immunization CE, this is an option. Again, it is ACPE accredited. And if you go to their website, they will give you, there are directions on how to report that to CPE Monitor and codes and everything else. I know that was a lot of information, but we're about 15 minutes until the end of the program. We have several questions that have come in. So we're going to turn it over to Tom, or I will turn it over to Tom to sort of interface and see how many questions we can get to.
So if you'd like to send us a question, go to your toolbar and type it in there and then hit send. Please send questions related to today's topic. We do get some that have no bearing on today's topic. We will not answer those first. We'll get to the ones with today's topic. So we have someone asking, is Class R planned to be temporary, or is this something permanent?
No, Class R is permanent. This is a statutory change. So once the rule is adopted, Class R pharmacies will be a part of Missouri law unless otherwise changed by the legislature.
We got a couple of questions related to pseudoephedrine. They want to know, does this apply to all pseudoephedrine products or just single ingredient or combination? The answer is it applies to any pseudoephedrine containing product. Someone else wants to know, if you do not register with NPLEX, does that mean you're not allowed to sell over-the-counter pseudoephedrine? And that is correct. Missouri law requires you to use NPLEX.
Someone asked, do we have an anticipated month date for telepharmacy applications? I'm assuming that means Class R applications. The board is working on the rule now. Again, they will be looking at I think, third or fourth draft on August 26th. That's an open conference call. That meeting notice has been posted and it's online if you'd like to join the meeting. Public members will be attending in listen only mode, but you can participate in that meeting and also provide comments via the chat box as well. But we anticipate hopefully approving that soon. The board has asked to have those applications ready as close to the effective date of the statute as possible. We anticipate September, but we still have a mandatory rulemaking process that we need to go through. So right now, a tentative date of September, but that is very tentative and depends on several factors.
We have someone asking if a pharmacist, let's say their employer sets something up supervision-wise, but the pharmacist isn't comfortable with it. What do you suggest they do with that?
So we get this question often, and I apologize, but we can't give you a very clear answer on this one, because we always remind licensees that it's your license, your responsibility, and you are responsible for keeping patients safe. If you are asked to supervise someone who you don't believe is competent to perform those duties, then I think you have an individual decision to make on whether you will continue with that supervision. It may put you in a compromising position of having to tell the permit holder and or the owner and or corporate that in the interest of my license, I don't believe that this is safe for Missouri patients. We would encourage you to do that rather than place Missouri patients at risk by doing something or supervising something that you believe to be unsafe. Now, when we go through inspection, of course, you can always file a complaint with the board. We would always love to look at anything that may threaten patient safety. So if you believe it's a patient safety issue, let the board take a look at it. But I would never, and we advise licensees all the time, I would never do anything that jeopardizes patient safety or places your license at risk.
We have someone asking a question about, they now have video in their sterile clean room. They want to know how these new regulations will affect that. It doesn't affect the supervision part. You cannot use technology to verify the final product. So if you're using a video system in your clean room, the final product still needs to be physically checked by the pharmacist before it's dispensed. But the supervision, it wouldn't, since the pharmacist is on the premises, technically technology isn't required, but you've gone a step further that you have it, but it cannot be used to verify the final product.
Someone is asking, how is a Class R pharmacy possible, given that 2.010, the board's rule still says that a pharmacist must be present for compounding, preparing meds, et cetera. Statute always trumps a rule. That is the law, both in the state and also federally. So we would have to, our rule would be preempted by the new state language or statutory language, and we would direct licensees to comply with the statute. Again, we still have rules pending, though, to fully implement Class R.
So we got a couple questions related to hospital practice, and I just have to say that within the hospital, our rules do not apply. That's regulated by the Department of Health. So one person is asking about hospitals covering for another hospital. Again, that doesn't apply. If it's activity within the hospital, that would be up to the Department of Health. And another has to do with supervising the clean room within the hospital. Again, that would be the Department of Health, unless those activities are related to something under the board's jurisdiction, such as if that sterile product was being dispensed to an outpatient, it would be the board's.
Someone is asking for remote data entry. The list of remote site, would that mean the tech's home address? Yes. We just need to know where they're operating out of. So if you just have a list of the addresses, the home addresses, if they're at an alternative or alternate location, you list those addresses as well. Again, this is in your discretion. Our inspectors will be asking to see it. I would note that the statute does say, does say that the board has authority to inspect that site if needed. However, the board will provide advance notice, and we would ask that the permit holder provide us a representative to accompany the inspector for inspections that may be at a technician's home.
This next one, I'm not sure if we're aware of. They're saying that you cannot, if you can't get your CPR renewed and you go on to do an NOIR online, it's not accepting an expired date. So what should they put in for that date?
Let me take a look at that. I know we had some issues right after the renewal window opened about not accepting an expired date. If you should then check the waiver box. If you don't have a current date, check the waiver box, and that should go through. But thank you for bringing that to our attention. We'll check again today to make sure that's just not a glitch on our side.
Someone's asking clarification on, can a technician take a verbal refill authorization at a remote site? They understand they can't take a new prescription, but could they take a refill authorization? The answer would be yes, as long as that's just a refill authorization. If they're making any kind of change to the prescription, then that would be a new prescription that would not be allowed. Someone's asking about a name change. Should that be done before the renewal or at the time of renewal? That has to be done beforehand on a separate form or process. You cannot do it on your renewal form.
Sure, and you should do it before. Now, if you want your name changed on your license, now if you want to continue your license under your former name, you can do that. You don't have to update it unless you want your license to reflect that new name. I can tell you for my bar license, it still reflects my maiden name. It has for 20 plus years. But if you want it changed, we will do that. But you do have to send us proof to support the name change, marriage certificate, court order, whatever that may be. Someone said they're no longer administering vaccines. Do they still need to renew their NOI? No, not if you're going to be if you're not going to be immunizing during the next renewal cycle. And you could always come back in during the renewal cycle as well if you decide to begin immunizing again in the future.
So someone's asking for clarification on what a tech can accept. They want to know, they understand they can't accept a fax at their remote site, but could the pharmacy receive it and then send that data over to the technician? And yes, that's exactly what the process the board envision is. All prescriptions should be received at the pharmacy, whether e-prescribed or fax, and then that data or scan would be sent to the technician working remotely.
Someone asked for confirmation. So if a tech is doing remote data entry and they live in Kansas and are operating from Kansas, can they continue that after the COVID exemption? And the answer to that is no. The rule says that the remote data entry site must be in Missouri. That is narrower than the COVID-19 waiver. You can continue to follow the COVID-19 waiver until December 30th. December 31st going forward, you need to comply with the rule. They need to be in the state of Missouri, and that's absent, again, further extension. Hopefully we won't need one.
Got a couple more questions on pseudoephedrine. The first one is, can a provider give an RX for a quantity larger than what the limits are? And the answer is yes. A prescriber can always write a prescription for a larger quantity. And then the other question had to do with if you sell something on prescription, do you have to report that to Implex? No, only OTC sales have to be reported. And then someone's asking about the 7.2 gram limit. Is that a federal law change? The answer is no. That is a state of Missouri specific change.
So someone asked, if you have one site designated as the hub or supervising pharmacy for a class R pharmacy, could you switch that hub designated pharmacy to another Missouri licensed pharmacy? And the answer is you could, but the site, the class R pharmacy, can only be supervised by one supervising pharmacy. So you cannot do sort of a round sort of supervision approach where you have 2 or 3 pharmacies that may supervise the same location on a different day. Only one supervising pharmacy per class R. You would have to change that with the board, actually apply to change that with the board. And then once that's changed, only the new supervising pharmacy could be designated. Someone asked about a pilot project. If you're working on a telepharmacy pilot program approved by the board, does the class R language void that project? So for those who may not be aware, the board was granted authority to approve pilot projects related to technology verification and remote data entry or remote dispensing. We do have a few pilot projects that have been approved in Missouri. If you're approved pilot project, you have authority to continue operating as a pilot project under whatever parameters the board approved for your project. However, you cannot do that in class R at the same time. You have to make a distinction. Board talked about this quite a bit on their mid-August call. You cannot do both pilot project and class R at the same site. You either comply with pilot project or you become a class R because of the different restrictions in both of those.
Someone's asking for clarification, I believe, to what you were talking about, the technician working in Kansas. Ken, they were asking about what about the pharmacist working from another state? Does that get affected?
Sure, if they're a Missouri licensed pharmacist. So the rule relates to technicians and intern pharmacists. 6.055 allows a pharmacist to perform non-dispensing activities outside of a pharmacy. A pharmacist could still verify or do non-dispensing activities from their home in Kansas or from California, or from whatever state it may be. The restriction would apply to technicians and intern pharmacists, and we're talking about a Missouri licensed pharmacist, of course.
Someone's asking if retired, do they need to complete the CPR and the NOI? And the answer is no, unless you come out of retirement and start immunizing again, then you would have to get those completed.
Sure.
Someone's asking, does the remote remote data entry rule apply to technicians doing long-term care order entry? And the answer would be yes, it applies to all pharmacies, regardless of what type they are. So yeah, those technicians would need to follow that if they're doing remote data entry. Someone's asking for clarification on telephone prescriptions. If a tech can't receive it at the remote site, it has to be accepted at the pharmacy, and that is correct. Only the pharmacy can correct that, could accept that. They again could provide that information to the tech who's going to remotely enter it into the system. We have someone asking about hospital pharmacy and jurisdiction on stuff compounded for the outpatient infusion center. What rules apply to the board of the Department of Health? It all comes down to whether that outpatient infusion center is within the Department of Health licensed premise. this can be a complicated question. It's best, and it's all case specific, so it's best to talk to your inspector or contact me about your scenario to get an answer.
So we have an interesting supervision question. So you have a set up 2 pharmacies under one roof, 2 separate licenses, one retail, one compounding. Can one pharmacist supervise both pharmacies? Our rules don't restrict that, but we, in our practice guide, we note that the pharmacist should be sure that they could appropriately supervise both entities. That possibly could be done under certain setups, but if you should never put yourself in a position where you are supervising pharmacies and you're not able to do so, even though they're licensed under 2, adequately do so, even though they're operating under 2 different licenses. So not prohibited.
So we're out of time now. We didn't get to all the questions. If you submitted a question we didn't get to, you can resubmit it to your inspector or to the board office on our website, and someone will answer that for you. So before we go, I need to go over some CE information. Our next webinar is going to be on September 17th. It's going to be a short compliance, and then the majority of it will be a question and answer session with some of the inspectors helping out answer the questions. So registration will probably come out next week, so watch for e-alerts on that. As I said earlier, we record today's webinar. It can take up to 15 days before we get it posted, and all our previous ones from this year are there. We had a regulation, a BNDD, and a Mo Health update, and we had 2 COVID updates earlier this year that are all on our website. For CE, you must complete the post survey to earn the CE, so do not close your browser. After I say I'm closing the webinar, a screen will show up saying I've ended it. You hit close. Again, do not close your browser. And then the survey will open. You answer the questions and click submit. If you do not get the questions on your screen, or we do have reports of tablets and phones, sometimes not getting them, you can email us at compliance@pr.mo.gov. We will email you the questions, but you must get them back to us within 24 hours to receive credit. We will email out certificates in approximately 30 days. We've switched to emailing them. So the last 3 or 4 we've done this year, we have been emailed. So watch your email for the certificate to come. So thank you today for joining our webinar. Thanks, Kim, for giving us such a good update on everything.
Thank you, everyone.
And I'm going to now close the webinar.
Stay safe and healthy.